Yes, good morning, Mr. Moser.
Good morning.
Ms. Morris. Just so that you know, we have read the skeletons, we've read all of the judgments, going back as far as Judge Bird, and we have read many, but speaking for myself, not all, of the authorities. So you can take it, we have a lively appreciation of the issues that arise, and so you can both cut your cloth accordingly.
My lords, I will try. I probably don't need to do introductions, and I'm leading Mr. Dillon, my learned friend is leading Mr. Tanker. My submissions, insofar as the court will find them of assistance, this morning will be in the following order. First, a very brief recall of the history of the litigation. I know it's at the forefront of everyone's minds. Secondly, as briefly as possible, comment on the three most relevant of the Braceurself decisions, including that of His Honour Judge Bird. I'm grateful for your Lordship's indication. I won't read them. I'd like to go through them and simply comment, because that will lead, thirdly, to ground one, which I will deal with specific reference to the judgment of Mr. Justice Fraser, as he then was, in Energy Solutions, which is a judgment that the deputy judge below appeared to consider he followed. I will aim to show that, unfortunately, he misread Energy Solutions in almost every relevant respect. Fourth, I will address ground two, the principle of effectiveness, insofar as it is not already covered by what has gone before. I do not propose to address our Edwards and Bairstow point in ground one in oral submissions, but will simply leave that as it sits in the skeleton. And then, in relation to what I will call the cross appeal on the facts, I would not propose to address this initially, subject to the court's guidance. I propose to leave it to my learned friend to set out her case, and then to the court as to whether it wishes to hear from the appellant on that point. My lords have seen the skeleton arguments. They know the case. It's a public procurement case, competition for a dentistry contract, two bidders, Powell and Braceurself, which is a firm through which two dentists, Mr. and Mr. Spathoulas, practice their profession. At least the following six matters are common ground. First, in marking the competition, NHS England made a manifest error. Second, but for that manifest error, Braceurself would have been identified as the most economically advantageous tenderer meet and winner of the competition. Third, there being only two bidders, Braceurself would have been awarded the contract in a lawful competition. This is not a loss of a chance case. Fourth, in fact, Powell was awarded the contract. Fifth, the trial judge accepted that Braceurself had suffered substantial damages. And sixth, at the Francovich damages hearing, Braceurself nonetheless recovered no damages, the breach being found to be not sufficiently serious. It is further relevant in this particular case that, one, there had been an automatic suspension of the award of the contract to Powell, which was lifted by His Honour Judge Bird on the basis that damages would be an adequate remedy. Two, but for the lifting of the suspension, it is unarguably the case that Braceurself would have been awarded the contract in the litigation after the liability judgment of Mr. Nissen KC. Anything else would have been unlawful and irrational. Three, instead, Braceurself has been left without any, let alone any effective remedy, neither what I submit as the primary remedy, the award of the contract, nor what the European Court calls the alternative remedy, the award of damages. And all that has taken place in circumstances where it's beyond argument that the wrong bidder is now in the contract, contrary to the rules, and, we say, the central aim of the regulations, namely award of the contract to the meat tenderer. And contrary to the guidance as I will aim to show, given in energy solutions. The three most relevant of the judgments below, they've already been mentioned, is first the suspension lifting judgment. It is in supplemental bundle tab 5. I will not trouble your lordships with the head note, which I know has been read. I'd like to start at page 164 of the bundle, paragraph 29 of Judge Bird's judgment, where he says, I turn to the arguments, and this paragraph summarises the arguments made by the NHS. And down by C, the last sentence is, there's no speculative element to the loss here because there were only two bidders. And if the claimant succeeds, it would be compensated in damages if the suspension were lifted, on the basis that it would have been awarded the contract. It follows that in both principle and practice, damages would be adequate. Now, I make no criticism of that submission. In fact, I say that submission was entirely correct and in line with the case law as it stood at the time in energy solutions. And it's plainly operated upon the mind of His Honour Judge Bird when he chose then to lift. There is a discussion that follows about the claimant being a business and damages only having to be adequate, not perfect. And then at 45, on page 167 of the bundle, taking into account all of these points, so on, I've come to the clear conclusion that in this case damages would be an adequate remedy. Taking the modern approach adopted by Coulson J, as he then was, and asking the question, is it just in all the circumstances that the claimant should be confined to his remedy in damages, assuming that there is such a remedy, which may include assuming that there was a claim for damages, and I'll come to that in a moment, then I've come to the conclusion that the answer to that question is also yes. The inquiry then stops there. The automatic suspension should be lifted. What was behind those comments was that damages at that stage not yet been pleaded, because not unusually the remedy that the claimant wanted was the award of the contract. And we see that at 52. The interesting point, I expressed the view that the question at this stage was not whether the claimant had chosen to claim damages, but whether damages would be an effective remedy. Otherwise, the claimant would be able to defeat an application for interim relief by not pleading damages. It was then submitted by the claimant that if the suspension was lifted, they would wish to plead damages. Perhaps surprisingly, at F, the NHS resisted an amendment to add damages, but that resistance was not successful. There was mention at 60, again unsurprisingly, of the Francovich criteria, and at 61, the judge says, 3 lines down, if I had refused to award damages, an interesting use of the phrase award damages, if I had refused to award damages, I'm of the view I would have needed to revisit my conclusion about suspension. There's also no criticism of the amendment at 62. The judge says that the claimant's approach had been correct and proper. And that's all I wanted to remind.
When he says, if I had refused to award damages, what does he mean?
Well, what he means is if I'd refused to allow the amendment for the damages claim, it's just almost insert a little brackets, sick, close brackets.
Yes, so if I'd refused to allow the amendment,
yes,
then he would have had to review his decision on suspension, which logically is right, because if he'd refused to allow the amendment so that Braceurself couldn't claim damages, then damages couldn't be an adequate remedy.
Exactly.
So he would have had to have reconsidered it. But he allowed the amendment.
He did.
And so damages were, as it were, in play. And I think it's right, isn't it, that that paragraph 60 is the only reference to the Francovich point.
Yes, that's right.
Can I just ask this? I mean, you're spending a bit of time with this for forensic reasons that I entirely understand. Does it make any difference to your forensic point that at this stage you hadn't identified the relevant breach?
No.
No.
The relevant breach emerged in the course of the litigation. That is not unusual. The breach existed. And at this stage, all that the judge needed to find was that there was a sufficiently serious case. It wouldn't have made any difference whether that particular breach had been mentioned or otherwise. I mean, I submit, it's fortuitous, but I submit that one of the procedural misfortunes that befell my client is that it wasn't the same judge hearing the lifting, suspension hearing and the damages hearing, because I ventured to suggest that His Honour Judge Bird would have had seared in his mind the fact that he considered that the claimant, if it ultimately succeeded, would recover damages, and that that was required as an effective remedy, which he mentions effectiveness, and that it was the decisive basis for lifting the suspension. It's not one of those cases where...
But it usually is, isn't it? In a public procurement case, when there's a battle about lifting the suspension, in my experience, 4 times out of 5, questions of whether or not damages are an adequate remedy are the key question.
Yes, absolutely. So that brings us then, as briefly as I can, to the liability judgment, which is in supplemental bundle 11, same bundle at tab 11. And the relevant question where the breach arose is dealt with at page 220. Question called CSD02.
Yeah.
And the complaint, paragraph 121 in the last sentence on page 221, was that the claimant complained its own score should have increased from 3 to 4. And as my lord Dingemans has mentioned, the breach, as it happens, emerged relatively late in the litigation, but I say nothing turns on that. And indeed, the learned judge himself found that nothing much turned on that. And we see that on page 223, at the end of that first paragraph, above the first whole punch, to do justice to the way the case was presented and contested, it's appropriate to construe this complaint on the basis the claimant is contending it ought to have received a higher overall score. Had the defendant properly understood what it was the claimant was proposing, and in not understanding the bid, the defendant made a manifest error. And that was apparently how it was argued. And your lordships have seen that there were 2 aspects that were misunderstood: the equipment proposed, and they thought that alternative premises were being offered for access, which they were not. And at 130, we see the first of those misunderstandings was, as we see in the 4th line from the bottom, Mrs. Farrack-Jones accepted it was an error to have interpreted the proposed item as a fixed stair lift. It was something called a stair climber. And the defendant also accepted that an incorrect assumption had been made in this respect. So we're dealing with an accepted and admitted breach, an admitted mistake. And in respect of the second point over the page, 131, the court found that the defendant had mistakenly assumed that alternative premises would be routinely available. And we see what happened in this case, that there was individual marking by the 3 assessors, and then a moderation meeting. And at the moderation meeting, we know from paragraph 135, the assessor in question agreed that she still hadn't understood the difference between a stair lift and a stair climber, and that she had taken into account extraneous matters. And at 136, we know what happened at the meeting. The other two had had a score of 4, and the assessor in question came in and said, due to the need to use alternative premises who are unable to use the stair riser, it is felt these patients would be disadvantaged. Happy with a score of 3, and she persuaded the other two to lower the score down to 3. Everything about the reason that she used to persuade the other two was wrong.
Well, she was wrong to equate the stair lift with the climber. What do you say about the point that, in fact, the climber itself suffered from the same deficits, which is I know it's picked up in the respondent's notice, but as you're concentrating on this now, rather than just taking it as read, you might as well deal with it.
But 2 points. The first is that on the facts, doing the best he can, the judge found that the climber did not suffer from the same deficits.
Why?
Because, as he put it, it was accepted by the witness in oral evidence that, for instance, a person with a broken leg may be able to use the stair climber. We see that at paragraph 139, pages 226 to 227. And the judge found, doing the best I can on the evidence provided, I conclude a stair climber could be used by a patient with limited mobility who was not in a wheelchair. It was not in dispute that it could be used by someone in a wheelchair. So, first of all, the judge found that it did not suffer from that difficulty. The second is that, as far as the assessor was concerned, she had no idea. She had no reason, no lawful reason, to believe that what she hadn't understood was a stair climber would or wouldn't be suitable or unsuitable for patients. She simply didn't know the difference. And as it turned out, on the finding that is not on the findings below, she was wrong. And of course, she was wrong about the alternative premises as well. So both aspects.
That was an error in some respects in your favour, in the sense that she thought it was going to be available generally rather than just. You're quite right. She made an error on it, but she thought it would be available generally rather than just in a particular situation of flooding.
Well, that was an argument that was advanced by the other side below.
Mm.
That was my learned friend's neat point, or however the judge put it. But it wasn't in our favour because she thought the alternative premises weren't good enough. So it's, again, irrelevantly and wrongly thought they wouldn't be good enough. And there may have been some confusion because it was the other bidder, it was the successful bidder that was offering alternative premises. But no, it wasn't. It wasn't, with respect, an assumption in our favour at all, and not used that way. And so, at least one of the witnesses over the page accepted, as she put it, that it was harsh to have criticised the adequacy of the claimant's alternative premises. So we see that the adequacy was criticised, not praised. It was more than harsh, of course, because they weren't even being proffered. And she was unable to explain why she had assumed it was. And the judge found that all of that had originated with the original assessor and the confusion sown by her. The judge wasn't satisfied that this automatically led to a manifest error. We see that at 143. And it makes reference to energy solutions. And then at 228, there is an important point which the judge makes about the margin of appreciation, although it is not, as I would say, picked up as it should have been in the liability judgment. The judge correctly identifies that the margin of appreciation is not relevant in determining whether a straightforward misunderstanding of the bid has taken place. So there is a margin of appreciation in marking, but put simply, there's no margin of appreciation in making a manifest error. And by the time you reach the stage of manifest error, as we'll see in energy solutions, any taking into account of margins on the way has already taken place. That's going to become relevant, my lords, because one of our points of appeal is that the judge didn't give weight to the fact that this was a no discretion case, because once you've reached a manifest error finding, the authority, the state, or the authority in this case, has no discretion in the matter to make or not make a manifest error. There is then the discussion of why the judge, having regard to the totality of the evidence, is satisfied that the point, the score would have been 4 and not 3, and the finding is made accordingly.
If you're leaving the liability
I am, yes.
judgment, can we just look at, let me just find it. Yes, 189, because in many ways, 189 sets the scene for the Francovich judgment and indeed this appeal.
Yes.
Because the judge is there, got the two opposing factors very much in his mind, hasn't he? I mean, he's found a manifest error which has had, in his words, drastic consequences. But he describes that as most unfortunate, given all the other things he said about the procurement. So there, in a nutshell, is the point.
Indeed. And it's picked up, as we'll see in a moment, almost immediately at paragraph 2 of the liability judgment, of the Francovich judgment. And in my respectful submission, the judge focuses unduly on what he considers to be the minor nature of the breach, because of the closeness of the two bidders and so on, rather than focusing on the drastic nature of the consequences. And it's the drastic nature of the consequences that I say ought to be the overarching consideration, indeed the decisive consideration in a case of this kind. In procurement cases, the scoring is almost always very close. Sometimes one is dealing, as your lordship knows, with procurements where you're looking at less than 0.5% vector.
Yeah.
The coincidence of whether or not the change required was small is not to be equated with the minor or other nature of the breach. For one, a change of 2.5% is not necessarily a minor change in procurement terms. But even leaving that aside, what matters is that it turned the procurement. And to say that 2.5% difference makes it notionally more minor or unfortunate, I know there are other reasons, but it's simply the wrong mindset with which to approach it. We'll see that suffusing the Francovich judgment from beginning to end, because he returns to it, the deputy judge, right at the end and says, well, it was minor. And also excusability looms large. And as we'll see, I criticise that, because excusability goes to errors of law, not to excusability of what was in fact done, even though we say it wasn't excusable in a very simple question, a very simple misunderstanding.
In some respects, this all flows from the fact that we're required to apply the Francovich test to something that, at least before the Supreme Court decision, had been thought to be just a breach of regulations and breach of statutory duty.
Well, exactly.
And anyway, we are where we are, and you are not making any submissions that the test ought to have been changed.
No, I'm not.
You can't hear anyway.
I can't hear. And however, I do submit that it has to be applied in a particular way in a procurement case. And so what we had in energy solutions in the Supreme Court was a change, a drastic change, in the way that damages are awarded in procurement cases in this jurisdiction. But in a sense, that...
Which sets us apart from France, for example, where they have straightforward breach.
And other places, as it happens. That change had been anticipated by Mr. Justice Fraser in Energy Solutions, where in the same case he had already found that Francovich damages were appropriate and indeed had the hearing and decided on the award of Francovich damages at first instance while the Supreme Court decision was pending, or the appeal to the Supreme Court was pending.
Well, he was applying the law as he saw it,
Indeed.
and he turned out to be right.
Absolutely. But in so applying the law, as we'll see very shortly, he also anticipated, and I submit, dealt with the problem that my Lord Justice Dingemans has identified by saying that in procurement cases where it is clear that but for the breach, the other party would have been awarded the contract, that will suffice for a sufficiently serious breach. And we see that reflected. I can point you to the authorities in due course. We see that reflected in the practice of the courts thereafter. So what happened after Mr. Justice Fraser in Energy Solutions is when you came to the automatic suspension lifting phase, there would then be an argument over whether Francovich damages would be adequate damages. And at that point, the authority, counsel for the authority, would tend to say something along the lines of, well, I concede that under the laws it stands at the moment in Energy Solutions, I think we've got an example of Mr. Coppell in Bombardier in the bundle, as it stands at the moment in Energy Solutions, if the finding at the end is that the claimant should have been awarded the contract, then damages will be awarded. What has happened after Braceurself, after this case, and there's an example in the bundle in the case of Box, is that the authority now has to make a somewhat fuller undertaking, give a somewhat fuller undertaking, sometimes referred to as the Braceurself undertaking, which is, we undertake not to argue that it wouldn't be sufficiently serious in the circumstances where the claimant would have won the contract. That's unsatisfactory and uncertain in a number of ways, because it is not supposed to be a DIY remedy where the parties have to fashion a situation at the beginning, at the suspension lifting stage, in order to get a suspension out of the law as it stands.
Well, one of the problems is that if damages are awarded, they're always tended to be claimed for on the expectation basis rather than what you might think is the true loss, which is that you wasted money on a bid where they bogged up the market. And wasted expenditure should then be the norm, and everyone would get what they contracted for rather than the relevant authority having to pay out two sets of loss of profits. One to the successful contractor who gets the profits, and you who say we should have had them.
Yes. Well, that's a matter for the legislator, though.
Well, arguably so is the earlier point, because if there was a law that said clearly, if the stay is lifted and the claim pursues in damages, you automatically recover damages in these circumstances, well, that would be different, but we're not in that happy position. So we're trying to reconcile a number of slightly awkward things, and you would be unsurprised, given my background, to hear me say that obviously I have considerable sympathy with overworked TCC judges dealing with applications for stays in procurement cases, and being expected to grapple not only with whether damages are an adequate remedy, which is the common argument, but going into enormous detail about whether a hypothetical breach is hypothetically sufficiently serious.
Well,
I
which
mean,
is
that,
why-
that way madness lies, so it seems to me.
Which is why the parties are now forced into a situation where they have to cut through it if they want to get their suspension lifted. That is itself unsatisfactory.
I mean, clearly the best thing would be to have an almost immediate trial of the issues. But the Ministry of Justice doesn't provide the resources for that, so we therefore have to try and find a way of squaring these various circles.
The TCC, with respect, does very well, of course, in having sometimes almost immediate trials, expedited trials in these situations. But again,
It does.
as far as the
If I
welfare
could,
and sanity
if
of
I could
everyone-
make the point with my lord sitting next to me, it needs more judges, but beyond that, I agree, it does do very well. But you understand the point that, that of course it would be better for those matters to be resolved, if they could be, at that interlocutory stage. But one knows that that's just not possible. And that's, I'm not talking now about the point about that this wasn't a specific claim at that time. I'm just talking more generally.
Well, at least under the previous approach in energy solutions, which I say is still the correct approach, they're both first instance judgments, albeit one a slightly more senior judge. Under the previous energy solutions approach, as I say, and as we can look at in the authorities if we like, the Francovich problem was solved in that way, which is that, well, if the most serious thing has happened, which is that the wrong bidder won, and you, claimant, you would have won it. Not loss of a chance, not one of the more grey area cases, but you would have got the contract, then that would be considered sufficiently serious.
Well, you'll come to that in the third part of your submissions.
I will.
I think I interrupted you. You were coming on to the Francovich judgment.
Yes, so that is at core bundle tab 6. I made my point about the judge starting off, in my respective view, on the wrong foot at paragraph 2 by talking about even minor breaches of duty. You can imagine a very egregious breach of duty. I mean, absolutely not this case, but you can imagine an assessor taking a bribe, for instance, in order to adjust just 1% that will turn the competition. So one absolutely has to look beyond the mere percentage. We see the outline of the law starting at 90. I won't go through it. Broadly speaking, at this stage of things, we don't take issue with what the judge is saying here. At 16, he refers to factor tame and energy solutions, Fraser J. The summary of the 8 factors in factor tame is at 18.
Yeah.
And the reference also to what Mr. Justice J said at first instance in Delaney, where he says, amongst other things, that no single factor is necessarily decisive. And you'll have seen in my skeleton argument that I say that's mistake number 1, the prime error that creeps in, particularly in relation to factors 1 and 2 in this judgment, that the judge loses sight of that or has misread it, in that he repeatedly finds that a single factor cannot be decisive, when one case cannot necessarily be decisive. And just so we don't rely only on Mr. Justice J, no disrespect to Mr. Justice J, that bit about single factors being decisive is, of course, straight from Lord Clyde in factor tame.
Yeah.
And we needn't turn it up, but for your lordship's notes, it's at page, it's authorities bundle, tab 10, page 554, between D and E, having set out the list and the fact that liability doesn't require the establishment of fault, Lord Clyde says no single factor is necessarily decisive. But he goes on and he says one factor by itself might, particularly where there was little or nothing to put into the scales on the other side, be sufficient to justify a conclusion of liability. And then follow the 8 factors. No single factor decisive, but necessarily decisive, but one single factor may be decisive in the right case. And of course, Lord Clyde was in no way foreseeing the developments in the law of procurement in factor taking. There's then, back into the Francovich judgment in the core bundle at 92, there is mention of ocean outdoor, which your lordships will, some of your lordships will recall. I take no issue, of course, with what is said there. It doesn't go anywhere, as far as today is concerned, in my view, in my submission, because my lord will recall it was a criticism made by me on behalf of my clients that an advertising opportunity hadn't been advertised as a concession contract. It was found not to engage the regulations, and it was reasonably remote loss of a chance argument. So very different from the present case. I was forced to argue on that occasion that every breach of a procedural requirement like advertising would automatically trigger a claim for damages, and unsurprisingly, that is not the law. There's then a reference to Alstom, which is one of those cases where Justice O'Farrell had to grapple with the Francovich condition. We see that I would say the usual concession was made in paragraph 24 here, at 38 of Alstom. That was me again, and indeed what I said in that case was, well, as the law stands, as the law stands in Energy Solutions, if it went to the wrong bidder and should have gone to Alstom, then it would be sufficiently serious. And that cut through the argument. There's reference to one other case, Consultant Connect, which is, I say, on all fours with Energy Solutions, which is the only other case, apart from Energy Solutions itself and the present one, that's, as far as I'm aware, that's gone all the way in relation to Francovich damages. And damages were awarded. We then see, starting at 94, the principles in Francovich being applied. And at 33, the first, and I, of course, stress the most important principle, is most economically advantageous tender. And the claimant, indeed, below also pointed to that, and Energy Solutions, not a loss of a chance case, and so on. And that the judge correctly finds that is a factor in our favour, and that's at 43. However, the matter then takes a wrong turn at 44, where the judge says, regrettably, 4 lines up from the bottom, the mere fact that the principle breached is important cannot of itself be determinative. And he, for good measure, he goes on straight away to say the same can be said of the second factor. As was clear from factor Tame and Delaney, no single factor is decisive. In my submission, error speaks for itself. Can I briefly at this point just go to paragraphs 27 and 29 of our skeleton argument? I don't think your lordships may have it elsewhere. It's a core bundle 3. And paragraph 27 is at page 25 of the bundle. This is where we point out that a key principle is the meet, and that's found in energy solutions. There is an error that I'd like to correct at the end of paragraph 27, where we say the judge further found that this was a stronger case than energy solutions. In fact, he found it would be just as strong as energy solutions. And so I correct that. And then, as I've just said, the judge then, however, apparently lost sight of both of those findings and set out no single factor being decisive ever. So that's that. Carrying on.
So that's the point, or the first point of principle, isn't it? I mean, you'll come to your submissions, but that's the first point of principle, that if the breach led to the claimant not being awarded the contract when he should have been awarded the contract, that's sufficient for Francovich purposes.
Yes.
Yeah. Yeah.
And certainly sufficient if it's not a loss of a chance case.
Well, that's why I put it in those terms. If he would otherwise have been awarded the contract.
I'm grateful.
May I just ask you this then? What does Francovich add to the normal breach of statutory duty claim? Because you have to prove causation to get climate damages for breach of statutory duty. And if you were going to get those damages under the breach of the normal principles, what does sufficiently serious add if it's always going to be satisfied?
It's not going to be every case where you find that.
But I thought you said every breach that was causative would be.
Well, every breach that was causative, as it were, 100% causative. We might have damages claims, say, for loss of a chance, where it's found when there was a 30% chance you might have got the contract. That I'm not going to speculate what would happen in all the permutations.
Well,
that would be a different case.
You wouldn't get through the Francovich aspect of that because you need to show the breach is causative in some respects.
Well, but in a loss of a chance case, it's causative in the sense that you only need to show a more than fanciful chance that you would have won the contract and suffered loss. So you do get loss of a chance cases where a percentage loss is recovered, even by a number of different bidders, each of whom have a sufficiently high chance.
Well, I've already shared my views about whether the assessment of damages in this area needs reform.
My lord, yes. But happily for me, that's not this case.
Can I at this stage stand back just a tiny bit and just, you define seriousness of the breach by reference to its consequences, I think. Why is that?
Because the first Francovich condition goes to the seriousness, goes to the importance of the principle that is breached.
Well, and I appreciate, I'm just looking at Lord Clyde's judgment, in fact, but in a sense you're defining the breach by reference to a principle.
Yes.
When is that in fact what the breach was in this case? And I'm questioning whether you're correctly identifying the breach.
At least one of the ways that we're putting it, and we'll see where your lordship wants to take me, but the principal way that I'm putting it is that the prime principle in play is award to the most economically advantageous tenderer, both under the rules of the competition, which have to be observed under the regulations, and under the regulations themselves, as identified by, for instance, Mr. Justice Fraser. And I know my learned friend tries to attack the principle and say, well, actually, prime principle is somehow other. And that's not what was found in energy solutions. It's not the case that I
but I mean, that I am trying to get you to address the point that's put against you, because in a sense, by defining the principle in the way that you do, you sort of necessarily end up with the result that you want to. I'm not saying you're not entitled to. That's the nature of your argument. But do we not need to go back a little bit more on a granular level and actually look at what the breach or what factor actually invites the court to do?
Factor does invite the court, and your lordship has page 554 in front of him, to look at the importance of the principle breached. And that's exactly what Mr Justice Fraser did in Energy Solutions. We see that, if I can take you to it.
In fact, I understand because of the nature of the case, that one was talking about a particular principle of community law that was breached. Here, are we actually talking about a more granular breach of a particular feature of the procurement process rather than a breach of the overall purpose of the procurement process?
We're talking about both, because the overall purpose of the procurement process, importantly, includes that you have to follow where where a competition on the economic factors leads you, which means that you mustn't make an award to someone who isn't the economically most advantageous tender. And we see, so that I'm not arguing this in a vacuum, how Mr Justice Fraser addresses this in Energy Solutions in a way that I respectfully agree with, where he says at tab 22 of the authorities book, the second authorities book, tab 22. He starts at paragraph 53, I think the pages aren't numbered, unfortunately, to address the purpose of the directive and regulations. The broad purpose of the directive and regulations is to open up the field of public works contracts to fair competition. And Lord Hope made this clear, so he's relying on that Supreme Court authority in risk management. And there's the citation there, the second half of which is the broad object of the directive and of the regulations that give effect to it is to ensure that public bodies award certain contracts above minimum value only after fair competition, and that the award is made to the person offering the lowest price or making the most economically advantageous offer. So that is exactly what Lord Hope says. And at 55, there's then a discussion of fair competition at 54. 55, in order that this is achieved, authorities are mandated both to hold a fair competition to conclude which tenderer is offering the lowest price or the most economically advantageous tender, and then once that conclusion is reached, to award the contract to that tenderer as the economic operator who has emerged as the winner of the competition. These two limbs are both important, although sequential. Little point in conducting a fair competition if the authority is not obliged to award the contract to the winner. And that, in my respectful submission, follows axiomatically. There's then a discussion of the tech-have exemption and other matters. Those two separate though connected limbs constitute the entire raison d'etre of procurement law, says a judge who is one of the most experienced judges in procurement law. And so I do not purport to and do not need to add to that analysis or finding. My learned friend says, no, but if you look at CJEU authority, if we look at my learned friend's argument at paragraph 35 of her skeleton argument, she purports, as she did below, to identify a different principle purpose by reference to page 71 of the core bundle, paragraph 35, by reference to Professor Arrowsmith, and also certain CJEU authorities. And she says, well, actually, it's opening up markets within the
It's all about the internal market.
It's all about the internal market.
Yeah,
To which, on the face of it, the answer is, but if the internal market is to do anything, it's to provide the best result, which is the most economically and advantageous tender.
Well,
With
my
respect
lord,
to
yes.
Professor Arrowsmith, that would seem to be the answer. But anyway, we'll let that point be developed.
Well, I'll take it just one step further, which is that even the authority that my learned friend relies on makes that point in my respectful submission. If we look at one of the cases that's cited there, which is HM Treasury ex parte University of Cambridge, which is at tab 17 of the first bundle of the authorities.
Just before you go there, because I don't want to, I think we're just drifting away from, not your fault, but drifting away from the point I was trying to get you to grapple with. When we talk about, when Lord Clyde talks about just the nature of the breach, the seriousness of the breach, and I looked at your pleadings. Now, bearing in mind, of course, that this breach was not identified until during the trial, I didn't expect to find it in your particulars of claim. But the breach that you're now focusing on of the need to award the contract to the most economically advantageous offeror isn't actually the breaches that you identified in the pleadings. I'm trying to put myself back into the position of for example, a judge at the application to lift the suspension, looking at what you actually say the breaches were. The breaches you actually, unless I've misread it, the breaches you actually identify aren't to do with this principle, this purpose that you're now focusing on. They were much more granular. They were breach of the various requirements of the procurement process, which does invite the court, I would have thought, to focus on the nature of those breaches of the requirements of the process, rather than this more elevated, overarching principle that you now sort of draw attention to.
My lord, in a scoring challenge, which this effectively is, what your lordship is putting to me would be, by contrast, an impossibly high burden, because the breaches are always going to be granular. It's always going to be about, well, in this question, you failed to observe the principle of transparency or whatever, and you marked it 0 when it should have been 3 or whatever. That is always going to be granular. But axiomatically, as of necessity, what that leads to is the award to the wrong tenderer, not to the meat.
No, that's the consequence. I'm just trying to focus on the concept of the nature or seriousness of the breach. And the breach, in this particular case, was a breach of one particular principle of assessment, giving rise to a change of 1 point in one of the criteria. This wasn't a sort of a much more serious sort of breach of the process involving some misfeasance or anything more radical. So what I'm trying to do, because I think the point is put against you, that you're focusing on the wrong thing, and that in fact the fact-to-tame requirements do require you to look more closely at the actual breach of the process, not the consequence.
But that would be the same in energy solutions, where there was a breach of the process.
Yeah, but it sort of picks up a point that
It so
Justice
happens.
Dingemans put to you, that in essence, what is this fact-to-tame requirement bringing to the party? as it were?
Well, perhaps I'll say this and then I'll come back to the answer that I was about to give. Perhaps this is not a good case in that sense, because the breach is so obvious in this case, in my submission, that it looks like I'm saying it's always going to be automatic. There will be other cases where it's far more problematic to make that submission. But coming back to your lordship's point, the nature of the breach, 2 things about that. The first thing is it's not the nature of the breach as pleaded necessarily, it's the nature of the breach as found. That's what the court has to grapple with.
Well, yes, but in a sense, if we take ourselves back to the poor old TCC judge having to grapple with this lifting of the suspension argument and having to try and figure out how to bring into play this question about the seriousness of the breach and whether in fact damages will be an adequate remedy, what's he got to go on other than the pleaded case? This is not a chancery pleading point, right? Just to be clear. This is saying at that interim stage, what's the judge got to go on?
But the pleading was, you should have given us 4 instead of 3, and then we'd have won. That's the essence of it. And
Yeah, but what was the breach that required? What was the breach that meant you should have been given 4 not 3?
as it happens, it was a manifest error in marking question CDO2.
And what breach of the various breaches? It's a breach of the award criteria, is it?
Absolutely, it's a breach of the award criteria.
So should you not be looking at identifying or answering the fact-obtained question by reference to this was therefore a breach of the award criteria? Was it a serious breach of the award criteria?
I'm perfectly comfortable with that, but I do both. Because as I say in my skeleton argument, and as I said in opening, it's a breach of both the award criteria. And by the way, following the award criteria is another principle, rule of the regulations. And it's a breach of that most important principle of awarding it to the meat. That you can't, in my respectful submission, put a sort of a breakwater or a ha-ha between the nature of the marking breach in a marking challenge and the outcome. What we were claiming was that we should be awarded the contract. When that went away, we said, all right, well then give us the damages that we should have had for not getting the contract.
No, I'm actually questioning whether the fact-obtained approach requires you to look at the consequences as opposed to looking at the actual nature of what went wrong. Because coming to it somewhat cold, certainly the authorities I've looked at do all focus on the breach rather than consequences. And if you read Lord Clyde's 8 factors, they all focus on, as it were, the conduct of the breacher, their state of mind and what they did and everything else like that. There's no mention of the consequences at all. And the way you try and join the dots is by pointing to the principle, and you say that's your gateway into looking at the consequence. I am questioning fundamentally whether that's really what this is all actually said to be about.
Well, if so, then I'm in the excellent company of Mr. Justice Fraser.
I know you are, so I'm just questioning whether Mr. Justice Fraser is right.
And even
Just put against you that he's not.
even the trial judge, who on ground 1 didn't find against my client on this point, he agreed with Mr. Justice Fraser that that was the principle that was in play. And he disagreed with my learned friend. So
I know, but I think against you it said, actually don't assume Mr. Justice Fraser is right, unless I've misunderstood.
well, that's certainly one of the several things that's said against me.
Yes, I'm just trying to get you to, as it were, grapple with it straight up, because it seems to me that before we get into any more granular argument, any more consequential, any more extended argument, I ought to have stuck my oar in just to say, on this point, I really need to get you probably to go back to basics with the authorities.
Well, I mean, if we're dealing with breach of UK law, and whether the principle of UK law, which is engaged, which is manifest error, was breached, then there is absolutely a manifest error found. You can't find more error than a manifest one, in my respectful submission.
Manifest doesn't equal serious, does it? Or does it?
Well,
I mean, it's obvious, but it doesn't mean it's serious.
it's
obviously wrong in a very minor respect.
I mean, in my submission, you've seen what we say in the skeleton argument. It's an oxymoron to say that it's a non-serious manifest error. But even leaving that aside, what we're looking for is the relevant breach of, as we used to call it, EU law, of the regulations as implementing the directive. And certainly the European Court of Justice, with respect, doesn't look at it in this way. The European Court of Justice absolutely looks to the result in its purposive and teleological interpretation of the law. And if the result of the breach is that the principal aim of the directive and the regulations, which I repeat is the award to meet, is not met, then as Mr. Justice Fraser found, and as Mr. Nissen KC found, then that prime principle has been breached. And that, I do insist, is the relevant principle that we're looking at in this case when we're looking at factor one of factor T. And that's, I say, that is happily entirely in tune with everything that has gone before, including in this case. And just to round off this bit, because then I needn't come back to it, at paragraph 35, my learned friend relies on this case of the University of Cambridge and the European Court of Justice.
So this is back on the, it's not the meat principle.
Yes.
Yeah.
And that's at tab 17 of the first volume of the authorities. Sorry, no, it's not. It's at tab 9, first volume of the authorities. You needn't be too troubled with the fact this is a procurement case.
Sorry, I just missed the reference. Give me it again.
Authorities Bundle 1, tab 9. And we see at page, internal page 18070, that is where the Court of Justice is discussing the purpose of the directives. And as I say, in all of these authorities, the CJEU approach is to look to take the purposive approach and to look at what is the purpose and has it been subverted. And we see at 17 the Court of Justice's version of what we have seen with Lord Hope in Risk in the Supreme Court. The aim of the directives is to avoid both the risk of preference being given to national tenderers or applicants whenever a contract is awarded by the contracting authorities, and the possibility that a body financed or controlled by the state, regional or local authorities or other bodies governed by public law may choose to be guided by considerations other than economic ones. In the language of the court, what that means is you have to award to the most economically advantageous tenderer. So even if we look at the CJEU itself, as my learned friend urges us to do, at least in one of her submissions on this, and I'm not sure, well, I leave it to her to make her submissions, but the Court of Justice, unsurprisingly, agrees with Lord Hope and Mr. Justice Fraser. So, as I say, ground one, coming back to the liability, the Francovich judgment, which was core bundle tab 6.
So you made the point about 44.
Yes. Clarity of the precision of the rule breached. Again, we make no complaint about the finding that the rule is clear and precise. What we do complain of is that again, at 50, it is found that unlike in energy solutions, this factor, even in combination with the first, cannot be decisive. That's an error. We then come to degree of, I'm going to take this relatively lightly and move on to energy solutions, where we'll see all of these points revisited. We then come to 3, which is the degree of excusability. And here we take issue with the judge's concentration upon excusability, and he comes back to that at the end, when what Francovich talks about is excusability of an error of law. And this, in a sense, takes me back to my discussion with my Lord Justice Snowden about is it or isn't it an oxymoron to say that a manifest error is excusable. We say a manifest error is not excusable in principle, but we also say that when the judge finds that the misunderstandings were neither egregious nor gross, on the contrary, they were minor. 2 points.
Why does the obviousness of an error judged with the benefit of hindsight mean that it isn't excusable when it was made?
Well, first of all, as in energy solutions, I will say this point doesn't even apply here, because we're not talking about an error of law. It was an error of fact that was made by the assessors.
Sorry, I'm
Secondly,
putting the question to you. You said it's an oxymoron. You said, how can a manifest error ever? So I'm looking at it that way. You look at the question of whether an error is manifest with the benefit of hindsight, and you say, is it now obvious that that was a mistake? Why, just because you conclude with the benefit of hindsight it's obvious that it was a mistake, do you say that it was an inexcusable one?
But
I mean, inexcusable surely means whether at the time it was made there was a reason for it, an excuse for it, a justification or an understandable factor which led to it. Why are the two so necessarily inconsistent?
but they're not necessarily inconsistent, but we
said
do
they were.
also...
I thought you said they were. I thought that your submission was they were.
Oh, sorry, it's excusability and manifest error. My primary submission is they are inconsistent.
Yeah.
But it's but running both of the points is not inconsistent, because we do also say, we've said in the Skeleton argument, that now descending to the facts, in this case, the error was inexcusable. If that were the correct test, and we're looking at errors of fact as well as errors of law, in the sense that this was, as we've pointed out, a very simple question in a very simple procurement.
I understand on the facts of this case, you say this error was both manifest and inexcusable. But your actual submission, I thought, unless I had misunderstood it, was that every manifest error must be inexcusable.
But as
in every case, if you can say that error is manifest, I think you say it must be inexcusable. It must have been inexcusable. Is that what
that's my principal
I
submission.
thought it was.
Yeah. But if I'm wrong on that, what really matters to my clients is whether it was excusable in this case, and we disagree with the judge.
No, but
We
of course,
say he is
but I'm entitled, I think, I hope, to at least question
absolutely.
the first and more generalised of your submission.
Well, we consider that once an error of law has been established in a procurement context, a manifest error, excusability doesn't play a role, because it's not the sort of error of law to which this point of Lord Clyde's is meant to go. So in Factor 10, they had legislated, in the Merchant Shipping Vessels Act, they had legislated to exclude Spanish fishermen flying under a UK flag. in the face of legal advice that they had received, which said that there was a risk that they would be in breach of EU law if they did so. And so the question was this legislative act an error of law that was excusable or inexcusable? And it mattered there, because if you've had legal advice that says, from eminent counsel, that says, well, you may be breaking the law here, and you go ahead and do it, then that is more egregious than if you'd had the opposite advice.
But we don't want to
But
get
that really
we don't want to
doesn't
get
apply.
too pigeonholed, do we, into the precise the 8 factors. Excusability is 3 and state of mind is 5. To me, they go, if I was sitting as a criminal judge, to culpability. The judge formed the view this was a low culpability case, to use the imperfect analogy with the criminal thing. So however it arose in factor time, that it must be right, mustn't it, that when a court is considering sufficiently serious, one way or another, it looks at the circumstances of the party in breach.
Yes.
And so that's what, to my eye, that's what certainly 3 and I think 5 are doing.
And here again, we come to what we say is a misreading of energy solutions as to state of mind. But here, in this case, both excusability of error of law and state of mind, we say, don't sit particularly well with facts of this procurement case, and certainly ought not to arise decisively to cancel out important factors 1 and 2. We see what the judge says on state of mind of the infringer from page 100 onwards in the Francovich judgment.
Yeah.
And again, he differs, if we look at paragraph 67, again he differs from the approach taken by Mr. Justice Fraser in Energy Solutions. Mr. Justice Fraser reported he had found neither bad faith nor a deliberate intention to infringe on the part of the NBA. And I say in parentheses, nor would you expect to in 99 out of 100 procurement cases, one hopes. And so he considered the 5th factor didn't apply. And I say that's the correct approach in a procurement case. Now, the judge read Fraser J's observations, and we see that a little further on in the paragraph, that this factor was unlikely to arise, as applying only to subsequent behaviour. I'll show your lordships that that's wrong. That with respect, that is not what Justice Fraser was talking about. He was talking about the 5th factor. He was talking about state of mind. And so, again, we see in my submission the correct approach in Energy Solutions, which is to say, well, those factors don't really come into it in this case, and the wrong approach with respect in this case, where too much weight was given to the fact that the party here wasn't in bad faith. As I say, that should be the absolute minimum expectation in free and fair procurement, that the authority and assessors are not in bad faith. Nobody is saying they were. And so
that, I think, is the second potential point of principle.
yes,
That you say that in a case where there's no bad faith, this factor becomes neutral.
yes.
So that if you're right on the first ground, you say that automatically makes it sufficiently serious. If you're wrong on the first ground and it is a balancing exercise, you say you're actually balancing 1 and 2 with, as it were, against nothing. So you get to the same result.
Yes.
Yeah.
And as a final fallback, if it's to be balanced against some notion that there was no dishonesty or similar, it cannot weigh very heavily. It's either nothing or a very light.
Well, that always is a more difficult submission in this court, because then it becomes a question of weight, which is why I've been so keen to identify the potential points of principle. I see that with both of those first two, you achieve a successful appeal on what you say are points of principle.
My lord, yes. And just to finish off the other factors, there's factor 6, subsequent behaviour was found not to arise. Factor 7, the persons affected by the breach was found to be essentially neutral, operating in favour of both parties in different ways. I don't want to belabour that point, particularly in light of what my Lord Justice Coulson has just said. We do take issue with the way that the judge looks at this in paragraph 84 in particular. And there is a point of principle, I submit, which is if you look at the impact on the claimant, again, the impact on the claimant is the most severe, which is to lose the contract it ought to apply. And the impact on the wider community, which the judge has said he has balanced it against, which he has essentially identified as being neutral, that's not really balancing anything against the prejudice to my client, or the loss to my client. So insofar as there is a balance to be struck on the last factor, I say it is in principle wrong to say the balance has somehow ended up as 0. Balance has, the scales have ended up in the middle, when in fact there was nothing to weigh against the disadvantage to my client. And there are then the other factors that we criticise when it comes to the balancing, and you've seen how we put that in the skeleton argument. There is another error in reading Energy Solutions at 88, over the page at 106.
88 is a sort of repeat of 44.
It is, but this time with the added ingredient that it is said that Mr Justice Fraser positively excluded from his consideration a single breach case, which had a powerful effect on the final score. And that clearly influenced the judge. That, I'm afraid to say, is wrong. I'll go to that in a moment. And again, with respect, wrong interpretation of Francovich cannot necessarily be determinative on its own. And finally, we've seen at 91, when it was then pointed out to the judge that there was an incoherent and unjust outcome between the lifting and the damages, he justified it with what we say is the wrong counterfactual. He looked only at what would have happened if damages had been asked for at the lifting stage. He did not, as he ought to have done, look at the counterfactual, the actual counterfactual, as it were, if that's a phrase, which is that the contract would have been awarded to us.
Well, you'll come on to deal with that point, because I think that's in your ground too.
It is, yes.
Yeah.
So that's effectiveness. And I essentially only want to go, my lords, to Energy Solutions, which we have already gone to in part, to make good these points.
So these are your ground 1 submissions, to the extent you haven't already made them.
Well, exactly.
Your ground 1 submissions by reference to Energy Solutions.
That's right.
Yeah.
So I am still on my third point. So Energy Solutions Authorities Bundle 2, tab 22. I think the facts are well known.
Yeah.
The claimant was one of the tenderers. directive and the regulations, the authority had to award the contract to the most economically advantageous tenderer. And the claimant claimed the authority had erred in its evaluation exercise. And there were two aspects. It was a scoring challenge and also a challenge that the winning tenderer ought to have been disqualified. The claimant won on both. Mr Justice Fraser found the authority had breached the regulations by erroneously scoring the tenders, and that the claimant should have won the competition if the score had been correct. He further found that the winner hadn't met two of the threshold requirements and should have been disqualified. So again, very much like this case, it was clear that the correct outcome would have led to the contract being awarded to the claimant. As I said, the authority received permission to argue Francovich before the Supreme Court, and pending that hearing, Mr Justice Fraser, taking the same view as the Supreme Court did, proceeded to determine whether the authority's breaches were sufficiently serious. Now, I'll repeat, as a general observation, that if it were right that one is looking at the individual breaches, then much of what Mr Justice Fraser says in Energy Solutions would be wrong. But, my lords, I respectfully agree with the approach taken by Mr Justice Fraser, and it's one I urge upon this court. And it's an approach to procurement law damages that was subsequently, of course, confirmed as a matter of law as being correct by the Supreme Court. And it's right to say that the Supreme Court didn't deal in detail with the findings of Mr.
I couldn't
Justice
find
Fraser.
any reference to this judgment at all.
No.
They were dealing with whether Francovich applied, and they said yes. But there was no challenge to this as I read it, and therefore it didn't arise in the Supreme Court.
Indeed, there was no challenge. But that, in a case in which just about every point was taken, I submit tells its own story. In Energy Solutions itself, there is reference, of course, to Factortame and Delaney, and Mr Justice Fraser goes through those at some length. At paragraph 29 of his judgment, he mentions Lord Clyde and also the Court of Appeal in Delaney. And at first instance, in Delaney, at 30, his lordship deals with what Mr Justice Jay said, Lord Clyde's non-exhaustive series of factors, and then the last sentence in that quotation is our ground 1 little 4. Although not expressly mentioned by Lord Clyde, I would add that in a minimal, no discretion type of case, it will be easier for the claimant to prove the requisite degree of seriousness. And that's based on established EU law principles. And we've mentioned the case of Robbins in our skeleton argument. Mr Justice Fraser goes on at 31 to cite from this, rejecting the submission of the Secretary of State, Mr Justice Jay's context is all. In a situation where the Member State's discretion is minimal or non-existent, a material breach of clearly worded provisions of EU law with significant consequences for individuals will often constitute a sufficiently serious breach for these purposes, and as a corollary but no more, a manifest and grave disregard of the relevant obligation.
Why is the significant consequences an indicia of what is a manifest and grave disregard? I mean, just to go back to my same old moan and worry it a bit more. I mean, if you're focusing entirely on the conduct, by definition, it may not always be obvious what the consequences will be.
It may not always be obvious. Well, first of all, it's obvious in this case what the consequences were.
Well, exactly, but I go back to the point that if one's assuming that there's an absence of deliberate dishonesty or anything else like that, that you're just simply dealing with an honest breach of the procurement requirements. It may not be at all obvious to the person committing the breach.
It may not be. And one of the points, my regular starting point is that you would hope that you're always dealing with an honest person and an honest breach, because you're dealing with the public authority.
You hope so, but not necessarily.
Well, it happens, not in this case, and not in most cases. The way that the European Court approaches it, though, is absolutely through the consequences. As we see here, the distillation of the EU law is where there are significant consequences for individuals. You would find the requisite sufficient seriousness. Manifest and grave disregard.
Okay, this is just Mr. Justice J.
Yes, but he's distilling the community law points that have been made to him in Delaney. And it's in the section where he's dealt with that, and he's dealt with factor tame. And one of the points that I made in that case was precisely that one, about the minimal no discretion type of case, which was picked up by the judge. And
speaking for myself, I'm not getting much assistance from this, so we may need to move on. The thing that's being dealt with at 30 and 31, and it's reflected subsequently in the submissions from the authority that the judge rejects at 52, is this question that there should be some sort of overlay of moral culpability or egregious conduct. And the judge says plainly that's wrong.
that's wrong.
And he's plainly right about that.
Yes.
That is what all of this is going to, and one can see as a matter of simple logic that if you're in a no discretion type of case, it may be easier to prove the requisite degree of seriousness. But as Mr. Justice J says, context is all.
Yes, I'll try and make my discretion point briefly, because it's not my main point, but it is a helper point, as it were, when approaching the breach in this case. Where an authority under EU law has little or no discretion, it is more likely that the breach will be sufficiently serious. And manifest and grave is simply a synonym under community law for sufficiently serious. The classic case is where a member state has to implement a directive by a particular date, 1st of November 2023, and hasn't done so. That's a no discretion case. That is, by definition, sufficiently serious, a breach of EU law. And that is how this works. But I say, trying as best I can to translate this into the very different context of procurement law, where a manifest error was made, there was no discretion. And the judge so found, of course. He said once it comes to manifest error, and especially once it comes to the outcome of the competition, there's no more discretion. There's no discretion in the authority or the assessors to make a manifest error. There's no discretion about awarding or not awarding to the meat tenderer. So insofar as we can compare that to a no discretion community law case, say, no discretion to implement a directive, we are in that territory. And therefore, it ought to be easier in such circumstances to find that there was a sufficiently serious breach. And the judge does do that in my reading of Energy Solutions at paragraph 57 of this case, where he first considers the different factors, and I come back to paragraph 57. But towards the end of that paragraph, where he talks about woods and lion apparel beneath the second hole punch, Mr. Justice Fraser says the NDA does not have any discretion at all once the conclusion of the competition has been reached. it is this conclusion that governs which of the tenderers are submitted the most economically advantageous tender. It's misleading to concentrate on discretion within the evaluation and seek to elide that, I skip a bit, with discretion on the part of the NDA itself. The margin of appreciation has been taken into account in deciding whether or not there was a manifest error in the evaluation. And the way I interpret this, and I submit it ought to be interpreted, is so it is here. There's no discretion about making a manifest error or where that leads you at the end of the procurement. And so we are dealing in cases of manifest error that lead to the wrong award with no discretion type cases. So that's the further factor, and it's in our grounds and skeleton, as I say, that comes into play in this case that wasn't addressed at all by the learned judge below. Back into energy solutions, the next relevant part I submit starts at paragraph 41 of that case. And this is the point related to the one I made to my Lord Justice Snowden, that both under the regulations and in accordance with the express terms of the competition, the tenderer whose tender was adjudged to be the most economically advantageous would be awarded the transition agreement. And that's perfectly clear there. As I say, it is here. This is factor 2. And a failure to do so is, in my judgment, a clear and rather obvious breach both of the regulations and of the rules of the competition. So factor 2, we say, established in the same way. But this way of approaching the matter shows the failure to award the contract is not only a direct breach of regulations 18 and 30 and of the terms of the competition, but also a breach of the directive implemented by the regulations. The regulations correspond to Directive 2004, and that is set out over the page. Pausing there, that is exactly the way in which I invite the court to approach the question of...
The judge
breach.
found for you on 1 and 2.
Yes, he did.
It's the consequences of 1 and 2 that is the first principle that you raise.
Yes, it is. I'm sorry. I was responding to my Lord Justice Snowden rather than the judge here, because the judge is actually with me on this. There is then at 43 that contentious passage which the judge read as Mr. Justice Fraser expressly excluding a single breach case. What he says at 43 is, however, the conclusion that the NDA was in breach of its obligations by awarding the tender to an economic operator other than the one who submitted the meat can only be reached after assessing the effect of other, more numerous breaches in the actual evaluation itself. What Mr. Justice Fraser is talking about here is the facts of that case. There were numerous breaches. It's talking about the NDA. And then he says, although it is possible to consider hypothetical scenarios, I say in brackets, hypothetical, i.e. not this case, in which there might be only one underlying breach in the evaluation itself, either a failure to evaluate at all or a single breach in the actual evaluation scoring that had an individual powerful effect on the final percentage score. In this case, there were a number of underlying breaches that led to the conclusion of an overall breach of the regulations and the terms of the competition. Mr. Justice Fraser absolutely isn't saying here, well, I exclude from my considerations an individual powerful effect on the final percentage score from one scoring breach. Everything that follows makes it plain that a single breach, in Mr. Justice Fraser's judgment, and with respect quite rightly, can suffice.
But he wasn't dealing with that.
No, it wasn't.
So it's hypothetical, as he says.
Exactly.
So it's irrelevant.
Well, it's irrelevant, but it's not what the
I
judge
take the
said.
point that the judge said, well, he excluded it. That may be putting it too high. It's hypothetical. It doesn't go anywhere. It's either excluded if the judge is right or hypothetical if this is right. But it wasn't the case that Mr. Justice Fraser was dealing with.
No.
He was dealing with a huge case with a raft of breaches.
What concerns me about the judgment below is that it appears to have influenced the judge, that he found that it was positively excluded,
Well,
which it wasn't.
Okay, be that as it may, I'm not sure that this is, as you said, a contentious passage. He's just saying that's a hypothetical situation which he doesn't have to address.
Well, he certainly didn't address that hypothetical situation. What he did address, as we'll see in his conclusions, is whether a single breach can suffice. And we'll see the answer is yes. Moving briefly through paragraphs 52 and following, because I've already read from them, that is where we have the most economically advantageous tender point, being the raison d'etre of procurement law. And I read as far as the end of 55 in my earlier discussion. 56, a failure to award the contract to the operator offering the most economically advantageous tender, what I've turned above the overall breach, goes directly to the heart of these principles. This can be seen not only from the purpose of the regulations themselves generally, but in this competition from the fact that this formed level 1 in the evaluation framework. So again, both the regulations and the framework, failure to offer the most economically advantageous tender directly to the heart of these principles. And then he considers the factors, and the first two at 57, the importance of the principal breach and the clarity and precision of the rule are made out, and I say in parentheses, as in this case, and lead to the conclusion that failure to award the contract to the most economically advantageous tender is a breach that would entitle Energy Solutions to damages, and I say in parentheses, and so it is in this case. In my judgment, the overall breach is sufficiently serious to satisfy the second Francovich condition. The importance of the principle is considerable and central, as is made clear by the dicta of Lord Hope. It is both clear and precise, not only that, underpinned by the fact that the criteria of the competition must also be clear and precise. So here we have factors 1 and 2 on their own sufficient. That's not how the learned judge below read it, and he was wrong. Then a few lines further down, Mr. Giffin sought to argue that the obligation to apply the evaluation criteria could not be seen as clear and precise.
Does this matter, given that the judge has found this factor in your favour? The only point of difference on 1 and 2 is that you say it automatically leads to sufficiently serious. The judge formed a different view. You say, look at what Fraser J says, not in this paragraph, but in the paragraph you showed us at the top of 57 and then later on at 65. He says effectively it does automatically entitle you on your submission.
Yes,
those surely are the key bits, not what he says on the facts of that case as to how 1 and 2 are made out. Because we know 1 and 2 were made out on the judge's approach here.
My lord, yes. And I'm happy to leave it there. I don't need to elaborate. Mr. Justice Fraser says it all. I will go to paragraph 58, though, before moving on, because that is a different point. That is the point dealt with quite shortly in this judgment about the excusability of the error of law. That's that point on which we dwelled for some time in Mr. Nissen KC's judgment. In Mr. Justice Fraser's judgment, that factor doesn't really arise in NDA. It is more likely to arise when liability for legislative or policy acts falls to be considered. And hence my example, not given here, of the member state failing to implement a directive by the due date. Even if it does arise and might be argued as including errors by the SMEs that could be characterised as errors of law, in that case he finds such errors weren't excusable. In our case, I say what happened cannot be characterised as errors of law at all. And so that's a factor that does not arise. There's no relevant judgment on the point. The factor doesn't arise. And then we have this business of the 5th and 6th factors. That's 61. And this is where the learned judge at paragraph 67 of the judgment says, well, when it comes to bad faith, then really this is something that operates only on the sixth factor and isn't relevant. We'll see, in fact, that it is the fifth factor that Mr. Justice Fraser is addressing. So he says at 61, turning to the fifth and sixth of Lord Clyde's factors, state of mind of the infringer and the behaviour of the infringer after it has become evident, and he then discusses the infringer. No findings of deliberate intention to infringe. However, this is below the second whole point. So far as correction of the score of a particular requirement is concerned, it matters little to an aggrieved tenderer why a manifestly erroneous score has been awarded. The important point is that the score was manifestly erroneous.
There it might be said, Mr. Justice Fraser was plainly adopting the wrong test. He's looking there at what matters to the aggrieved tenderer. That's not the test.
Well, that's not the test, but
That's not the test for 5, because that's the mind of the infringer.
No.
So I've underlined those words and written in the margin, not the test. I may be wrong about that, but that's what I've done, because it seems to me that goes much too far when you're looking, if you're applying point 5 of factor tame, the mind of the infringer, it's got nothing whatsoever to do with the aggrieved tenderer. Completely understand why the aggrieved tenderer is going to be a relevant factor for some of these, but not for this one.
No, I perhaps generously didn't read that part as being Mr. Justice Fraser setting out the test. It's in the next sentence where he starts to deal with, in my submission, the test. I do not consider this factor should be interpreted to mean that intention or lack of it will be of direct relevance in every case. And he discusses what Lord Clyde said, and at 62, what Mr. Justice Jay said in Delaney, where he said, if the government acts in bad faith, that is an additional
This
factor.
is the second point that the second point of principle we identified
Yes.
a little earlier.
Yes, and I do rely on the fact that in further down in 62, just above the second whole, there is that sentence. It is also very difficult for any court in a procurement case to consider the state of mind of the infringer if that is taken to mean the individual evaluators. And I respectfully agree. And an authority could potentially, in an extreme case, choose to defend a procurement town without calling any evidence at all.
Well, here, of course, again, we did have evidence.
Yes, but with great respect, I submit that the fact that the judge ventured a view that the fact that the evaluators weren't in bad faith somehow gives a clue as to what the relevant state of mind is something that he ought not to have done. Requiring express consideration, says Mr. Justice Fraser, of not only whether an evaluation was manifestly erroneous, but also why it happened, would expand the scope of the inquiry very widely. Could in many cases simply not be possible. I do not therefore consider that this factor will arise to any appreciable extent in the vast majority of procurement cases. And, my lord, I prefer this approach with respect to that taken by the learned judge, who not only considered that the factor did arise, but considered it to a very appreciable extent. Indeed, it appears to be a very important part of his eventual conclusion that what he balances against factors 1 and 2 somehow outweighs it. As I said, I just very briefly make that good by just dipping back into the judgment, is that the judge seeks, it's at tab 6 of the core bundle, the judge seeks to apply this by avoiding what Mr. Justice Fraser says, and at paragraph 67 of his judgment, which is at page 101 of the core bundle. He says, as I read at 67, the last sentence, as I read 62, Fraser J's observation that this factor is unlikely to arise to any appreciable extent in the vast majority of procurement cases was intended as a reference to the 6th factor, subsequent behaviour. given that is the subject matter with which 62 is primarily concerned. Now, we've just looked at paragraph 62 of Mr Justice Fraser. It is in the context of him addressing both the fifth and the sixth factor, and it is plain that this aspect is one that he's addressing in the context of the state of mind of the infringer. That's the whole context of the end of paragraph 62. So it is not primarily concerned with factor 6, as the judge held. It is primarily and only concerned with factor 5.
But may I just ask something at the end of paragraph 62 of Mr Justice Fraser's?
Yes.
And the judge there said, well, it didn't arise in my case, and it's not likely to arise in many cases for the reasons he gives, but he doesn't say it can't arise in an appropriate case.
No, he doesn't.
So, I mean, does this really help us very much anyway?
It doesn't help us very much, but it's the correct approach, in my respectful submission, that unless there is something exceptional, and in particular negative about the state of mind of the infringer, in a procurement case, it ought not normally to arise at all. And it doesn't arise in this case that the evaluators didn't give their mind to anything other than trying to evaluate the question.
Well,
So be it.
The judge's findings as state of mind was that, and he obviously took it into account, was that they'd approached their task diligently, carefully, made this one minor error.
But the problem with that is that, again, that ought to be the standard situation. They ought to be approaching.
Well, we all know procurement cases where they're manifest errors and the authorities are littered with them. And this was, I mean, unusual in the sense that it was just one minor error. You're right that quite often there's not much between the marking, but it's unusual just to find one minor error that just happens to be critical.
I, of course, take issue with the starting point, that it's a minor error, for all the reasons I've given. It's unusual but not unheard of that there is one error that makes the difference. And because it's always so close, or almost always so close, certainly in the litigated cases, because the parties look at the difference and go, oh, I'm only 1% behind, well, better look at this. It's not at all unusual that one error, or few errors, leads to the difference. Whether it's one or two, ought to make no difference. It's the same principle. It is a manifest error, and it has led to whatever the adjective is that one prefers. I can't remember whose it was. Mr. Justice Fraser was it, who said it was drastic.
No, it was the judge.
It was the judge, I'm sorry. And that's right. And I
The
said
judge is completely on top of the point. He
well,
just came to a different view to the one you would have liked him to come to. But the judge, it's the judge who says drastic.
he uses the word drastic,
Yeah.
but he loses sight
Not
of
before the and in the liability judgment, not the Francovich judgment. He was on top of the point before the argument had even got going.
he was, but he loses sight of the drastic, and gives too much and unlawful, in my submission, emphasis to the minor, because there is an obvious legal reason why it's drastic. There is, in my respective submission, no obvious legal reason why it's minor, or any. So very far then from this being a case where Mr. Justice Fraser excluded a single breach that's decisive, we see already pre-advertised by my Lord Justice Coulson what happened at paragraph 64 to 66 of Energy Solutions. One factor by itself might make a difference, in particular in a minimal no discretion kind of case. And in his judgment, this was a no discretion type of case for the reasons he's given. And for exactly the same reasons, I say this is a no discretion kind of case in Braceurself. In my judgment at 65, first and second factors without more are sufficient to justify a finding. It is inexplicable with respect.
Go on.
How the judge
No,
reading,
in this paragraph,
sorry, in my judgment,
that's the
sentence,
first sentence.
without more, are sufficient to justify a finding that the breach by the NDA of the obligation to award the contract to the most economically advantageous tenderer is sufficiently serious to satisfy the second Francovich condition. The presence of these two factors and the facts of the case means that the breach by the NDA represents a manifest and grave disregard of its obligations.
So the second sentence would suggest more than just those two factors. I agree the first doesn't, but the second does, doesn't it?
Yes, it
The
does.
presence of these two factors and the facts of the case mean that.
Absolutely, and that's reflected.
So it's not automatic.
Well, that's not my reading with respect. So what the judge is saying here is the first and second without more are sufficient. But then he's saying that there are many other factors in this case. So you've got the presence of these two factors and the fact of this case, which means it's manifest and grave. And that interpretation, I say, is clear if we then look at the findings of paragraph 72.
If we're just about to leave 64, can I ask you one question, if that's all
I'm
right?
going to come back, but yes, absolutely.
Well, no. I mean, if you're going to come back, it was just at the end of 64, and just your bright line proposition that every sort of causative breach is always going to result in damages seems, on one reading, inconsistent with the last sentence where it says it is therefore easier for energy solutions to prove a necessary degree of seriousness. It doesn't say will always happen.
Oh, that's that. Well, but this is the no discretion point.
Yeah.
Yeah, the no discretion is not going to be decisive in every case, but in every case where there is no discretion, you are, as it were, already at least teetering on the brink of sufficiently serious. And that's what the European Court says about no discretion cases. So it will normally be easier to find the necessary degree of
But it
seriousness.
doesn't always translate into a breach.
Not always. There will be little or no discretion cases where, for some reason, there might not be sufficiently serious breach. But that may just be the Court of Justice keeping a door open.
Well, it seems that Lord Clyde did, and so did Mr. Justice Fraser.
And I'm not saying that I need to say that this is an automatic no discretion, therefore breach case. I do say this is a no discretion case, and therefore ought to be much easier to argue that this is a sufficiently serious breach. That is an additional point. It's a gloss on my principal case, which is that failure to award to the meet is sufficiently serious. Because as it happens, that arises in a no discretion context here. And that's how those cases work. And I've mentioned failure to implement. That's just at the most extreme end of the scale. There'll be a whole scale of community law breaches where there is more or less discretion, and that the full quotation from the court is always little or no discretion. Now, if there's no discretion, you really are pretty much in the field of automatic breach, sufficiently serious breach. But I wouldn't go that far, and I don't have to. So particularly viewed in the no discretion context, first and second factors without more are sufficient. And then my Lord Justice Coulson says, but isn't that overstating? But as I submit, this has to be read with the findings of paragraph 72. And the first question is whether a failure to award a contract to the tenderer, whose tender ought to have been assessed as the most economically advantageous offer, is in itself a sufficiently serious breach of the contracting authority's obligations to warrant an award of damages. And the answer is yes. And that is the general question. And that's
That's
how
his
I read-
answer to the preliminary issue drafted by the parties.
Sure.
And his reasons for it are scattered about in the judgment, including the 65, which you've just taken us to.
Yeah, but I say that they work in tandem. The first bit of 65, I say, relates to the general point, because if we then look at 2, that's where the judge moves on. If not, whether in all the circumstances of this case, the breaches by the NDA of its obligations are sufficiently serious to warrant an award of damages. So we come on to that second part separately. Answer does not arise given the answer to issue 1 above. However, an individual breach by the NDA of its obligations is sufficiently serious to warrant an award of damages if it is a breach of obligation in relation to threshold requirements or one designated pass-fail. For all other breaches of obligation in relation to valuation requirements, these are sufficiently serious to warrant an award of damages if they would have affected the conclusion, whether individually or cumulatively, of the competition, and which tenderer had submitted the most economically advantageous tender. And I submit this is entirely clear as a proposition that an individual breach that affects the award to the most economically advantageous tender is a sufficiently serious breach, whether, point 1, it is viewed in the abstract and in general, or point 2, as part of all the circumstances of that case with all the other breaches. The judge could have stopped in his answer to number 2 at the end of the first sentence, but he didn't. He went on and said all the other breaches are sufficiently serious, and he added, just for the absolute avoidance of doubt, whether individually or cumulatively, each one of these was sufficiently serious. Each decisive mismarking, each failure to disqualify the tenderer was individually sufficiently serious. And I submit that it is, regrettably, a misreading of energy solutions by the learned judge below when he finds the opposite and says, no, individually it's not enough, and then does the whole exercise as he did it. In a procurement case, and certainly a procurement case of this kind, this is, in my submission, the correct approach. And my last point on this, unless your lordships want me to address anything else in this judgment at this stage, is that I want to deal briefly with what is said against me by the defendant about automaticity. Because about automatic breach, that they're saying, well, this is my submission is one, that this is a subset of cases where there is a new test, a test of automatic damages. And I have largely dealt with at this point in my submissions so far, and I'm not going to repeat all of them. And the principal one, of course, is that in a procurement context, as I've just said, this is a sufficient breach. But why do my learned friends say that this ought not to be the case? They say, if we look at their skeleton argument, at paragraph 28, it's at core bundle 5. Paragraph 28, new test of automatic damages, and 29 fails to give effect to the word may in regulation 98 of the PCRs. It would mean there's a subset of cases in which the discretion that Parliament has conferred upon the court does not apply, contrary to the findings of the Supreme Court in Energy Solutions. Now, I respectfully take issue with that reading of both the regulations and the judgment of the Supreme Court. The Supreme Court in Energy Solutions did not hold that Parliament has conferred a discretion on the court in awarding damages. Can we please turn to Energy Solutions in the Supreme Court, which is Authorities Bundle 23.
Mr. Moser, I'm conscious that we need to pick up the pace a bit, because if you're going to be replying on some of the points in the respondent's notice, then I think I need to start Miss Morris before the short adjournment, and you haven't yet dealt with the ground 2 point.
My lord, yes, I'll be as swift as I can on this, and it is, if we look at paragraph 8 of the Supreme Court, which is at page 1380, the question of discretion was raised below before Edward Stewart J. issued 1, appears to have given rise tangentially to an argument which no longer directly arises that damages were discretionary. The argument about discretion was overtaken by the Francovich point. True it is that at paragraph 39, Lord Mance states on page 1395 that he considers that the regulations as amended should be read as providing for damages only upon satisfaction of the Francovich conditions. That is also consistent with the use of the word may, which otherwise seems to me to have no real significance. But in so saying, that's page 1395 between A and B, in so saying, Lord Mance isn't saying that there is a general discretion. He's saying the word may reflects the fact that the Francovich conditions will have to be satisfied. And of course, if they're not satisfied, damages will not be awarded. The point about the short point, and it's supported by Professor Arrowsmith for what it's worth, the short point is that Francovich damages don't work as a discretion. Wherever the Francovich circumstances are, tests are met,
I agree with you about this.
the court must. My learned friend agrees with me about this, and I needn't press it further. So, my lords, principle of effectiveness, we also rely on the principle of effectiveness. And we have set out the relevant points at paragraph 53 of our skeleton argument.
Can I just be clear so that I understand this point, these points, where they fit in? We've identified 2 potential points of principle that you raise. One is the, if 1 and 2 are made out, that's it. And the second is, well, even if that's wrong, unless it's bad faith or moral turpitude of some sort, then there are no factors the other way, and so again you'd be successful. So we're looking at this presumably on the basis that you're wrong on both those grounds, because if you're right on either of those grounds, then it doesn't arise. So is that right? We're looking at effectiveness if you're wrong on those points of principle, and so the judge has done the balancing act. You say there's some, overarching entitlement despite Francovich and the judge's analysis. Is, I'm not quite sure I understand, as you can tell, I'm not quite sure I understand how this fits in.
First of all, there is an obligation to consider the principle of effectiveness generally when applying the Francovich principles.
No, I'm sorry. I'm cursed with a very logical mind. We are operating on the basis that you've lost the first 2 points. On that assumption, because if you hadn't, this point wouldn't arise, as I understand it. But you say this point arises in any event and somehow overarches everything else. And I'm not quite sure I understand how or why that can be put that way.
It arises because of the facts of this case and the effectiveness or otherwise of the combination of the lifting decision and the damages decision at the end of it. In circumstances where the court, and it's the same court even if it's a different judge, has lifted the suspension so that the contract can no longer be awarded, in order not to breach the principle of effectiveness, it becomes necessary to provide at least one of the two alternative forms of damage that are provided for by the Court of Justice in circumstances, and I do come back to that aspect, which is simply the fact of the case, in circumstances where the claimant would have been awarded the contract.
Yes, oh, cool, I get that.
And,
So this would, there's an automatic entitlement to one of the forms of relief, and since you can't have the contract, it must be damages.
my lord, yes.
So that would short circuit Francovich.
It would be on these particular facts a way in which the Francovich test would be applied in accordance with the principle of effectiveness.
Well, it wouldn't, because it would be an automatic entitlement. You can't have the contract, therefore, because damages were found to be an adequate remedy, so the stay was lifted, there is then an automatic entitlement to damages. It must be right, mustn't it?
Well, my lord, I won't shy. I'll put it differently, but I won't shy away from that being the effect. And my learned friends say that can't be right because this isn't contiguous. There's a different test for lifting than there is for damages, and it cannot be unlawful to have a case where suspension is lifted and in the end the breach is not sufficiently serious. Now, as far as community law is concerned, I submit that the best that can be said is that this is not a case that the Court of Justice has answered, and my learned friend has produced the authority of Spiker, and it's probably fair for me to deal with it before she makes her submission so she knows what I say about it. If we were still a member state, it might be that this would be a matter for reference, but not if I win on the first points. We're not, and the court has to grapple with it. Can I perhaps go to Spiker, because that's the basis on which my learned friend founds paragraphs 55 and following of her skeleton argument. And that is at authorities bundle. Give me, I've just lost the reference. Somebody can perhaps remind me. 15, tab 15 of authorities bundle 1, thank you.
While we're turning it up, can I just also ask, you talk about damages and everyone just talks about damages in procurement cases and the hope that it gets them to a negotiation and they get some money and it's all unprincipled. But if we're just talking about the principle of effectiveness, then this would be a situation where an effective remedy would be just giving you your wasted expenditure on a bid that wasn't fairly carried out or not accurately carried out. That would be, for example, the approach in French law.
I take issue with that because the approach under English law is that you're entitled to loss of profits.
Well, why should you be if you're trying to make this an effective remedy? You wanted to stay, the judge lifted it, and as it turned out, you say shouldn't have done. You want it effective. What you lost was putting money into a bidding process where it wasn't accurately carried out according to the bid process.
But what we lost was the contract. We were the incumbent. If this had been properly carried out, we'd be the incumbent now. And we would be making
Why does it
profits
matter whether
associated
you were
with
the
it.
incumbent?
It's background, but if it was correctly marked, we would be the incumbent now.
Yeah, the fact you were in the incumbent before actually doesn't matter at all. The question is whether you would have obtained the contract.
It's evidence as to it was run profitably before, but that's background.
But you have no presumption of getting a contract just because you've been the incumbent before.
No, on the contrary, that would be unlawful.
Exactly. So I don't think it actually matters.
So the case of Spiker is a slightly strange case in which the Dutch courts were initially concerned that there might be two different types of Dutch courts that have jurisdiction over procurement matters, one dealing with the preliminary lifting issue and another dealing with it later. The Court of Justice, and I think I can short circuit this, took a different view. The concern of the Dutch court is at paragraph 34 of this judgment.
Well, I'm afraid it isn't. This is one of numerous extra documents that were provided. So I've now just got 3 pages of this, which was a document that came yesterday.
I'm sorry about
There was a fuller report, and my clerk must have read the letter as taking that out.
are all of your lordships afflicted in a similar way?
I've still got paragraph 34.
Right. May I hand up a copy of Spiker? It's my learned friend's authority, but we have a spare copy.
The 34 begins in those circumstances, the Rechtback asking.
Yes.
Yeah.
So we see the concern of the
Yes, this was the version I had before the stuff came yesterday. Yeah.
We see the concern of the Rechtbank assing in 34.1. Must EU law be interpreted as meaning they haven't complied with legal protection in relation to procurement if it's impeded by the fact that conflicting decisions may arise under a system which both administrative courts and civil courts may have jurisdiction with respect to the same decision and its consequences. If we turn on to how the court treats that first question, at 43, it says, well, we don't give preliminary rulings on hypothetical questions. And at 44, they say, actually, the order for reference shows us that the first question is based on a false premise. And because at 45, it turns out under Netherlands law, the civil courts generally have exclusive jurisdiction. And it would therefore be impossible, last sentence, for an administrative court both to have jurisdiction concerning the same dispute. No risk of contradictory decisions at 47. 49, first question must be regarded as inadmissible. So that the main concern of the court about two different courts doing the front and back end of the case doesn't arise. Relevantly, for present purposes, the third question at 66. By its third question, the referring court asking whether the directive must be interpreted as precluding a court hearing an application for interim measures from ordering an awarding authority to adopt the decision to award a public contract, which in the course of a subsequent procedure on the substance will be declared incompatible with Directive 2004. Again, at 68, court identifies the premise of that question, that the court hearing the application for interim measures has ordered the awarding authority to award the contract in question to a particular tenderer. That is not how the court sees that situation. Again, at 73, that hypothesis doesn't obtain in dispute to the main proceedings. So the court does what it often does, and it rephrases that question at 74 in order to give a useful answer necessary to reformulate the third question. The National Court is actually asking whether Directive 89665 must be interpreted as precluding a court hearing an application for interim measures in order to adopt a provisional measure from carrying out an interpretation of Directive 2004-18, which is subsequently classified as erroneous by the court dealing with the substance. And my learned friends say, oh, well, that is, in a sense, this case. And then the finding on that, the answer to that question is at 77. Now, before we read the answer, one would think that the answer to that question is perfectly obvious, and that's perhaps why the court decided to ask itself that question for an easy answer. And indeed, it gives the obvious question at 77, which is the bit that is extracted in my learned friend's skeleton argument. Given the possibility of making provision for such a system, the possibility cannot be excluded. The court hearing an application for interim measures and the court dealing with the substance, called upon successively to deal with the same dispute, might give a divergent interpretation of the relevant EU legal rules. The court hearing an application for interim measures is called on to give a decision in an urgent procedure, and so on. On the other hand, the intervention of the court hearing an application is not designed, like that of the court hearing the substance, to rule definitively on the claim presented to it, but to protect provisionally the interests at stake, possibly by balancing. Well, my lords, nothing about that can possibly be in dispute. What it doesn't do is answer the question in this case. It doesn't say, well, what if the assumption turns out to be wrong? Where that answer might have come would have been the fourth question. The fourth question starts at 81. Whether an awarding authority may be held liable where it makes a decision to award a public contract following a direction to that effect by a court hearing an application for interim measures. And that decision is during subsequent proceedings on the substance declared incompatible with the awarding of public contract. I mean, even if answered, this probably wouldn't give us very much of a steer, because it's again a rather general question, not directed at what is manifest. But as far as effectiveness is concerned, it's interesting what happens next. Again, we're told that this is now redundant because it's the wrong hypothesis, and over on 83, this just isn't the case in the dispute. And so it's not necessary to answer the fourth question. The court could have stopped there. Normally it does, but it says part C of the fourth question asks whether the awarding authority has to make good the damage arising from an infringement of EU law. And it is instructive, I say, to see what the court has to say about this, because it then goes on at some length to say that, yes, the authority does have to make good that damage in a particular way. The first answer it gives, even if that appears not to be the approach in France, as my Lord Justice Dingemans points out, the first answer is at 87, which says that the provision in the directive about awarding damages gives expression to the principle of state liability for loss and damage, i.e. Francovich. And the court has held that individuals harmed have a right to reparation when three conditions are met. And we have Francovich and Factortame set out in 87. 88, as matters stand, the case law of the Court of Justice has not
Where's
yet...
this going? I'm
sure
it's my fault. Where's this going on the point about interim and final awards?
Where this is going is that it doesn't do what my learned friend says in the skeleton argument it does, which is answer the question about interim and final for the reasons I've explained.
Well, there's plenty of English law that does that. I know that's probably a heretical view, but that would be my view.
And where it's also going is paragraph 91, where the court, in the context of Francovich and procurement, says it is apparent that the detailed procedural rules governing actions for safeguarding an individual's rights under EU law must be no less favourable than those governing similar domestic actions, principle of equivalence, and must not render practically impossible or excessively difficult the exercise of rights conferred by EU law, principle of effectiveness. So, my lords, although the court doesn't answer the question, what it does do is it gives a heavy hint that Francovich may be relevant, and it says expressly...
But you say Francovich isn't relevant.
Well, no, it's relevant to the assessment of damages.
No, not on this basis, because on this basis you say it's an automatic. Because you've been deprived of the contract, you're only entitled to damages. The principle of effectiveness, you say, entitles you to damages because you didn't get the contract, because the judge on the first application lifted the stay. So Francovich doesn't matter. You get damages.
With respect, that's Not my submission.
What is your submission
My
as to
submission
how
is-
this gets you home if you've lost points 1 and 2?
Yeah, let me deal first with your lordship's proposition, which is that Francovich doesn't matter. Francovich matters absolutely in my case. It's just the case that the test is met in Francovich. I know that
So
your
the
lordship
test is
saying-
met because you were deprived of the contract by Judge Bird.
Well, the test is met. Your lordship started. Perhaps I'm overinterpreting what your lordship said.
You're presuming you've lost points 1 and 2.
I see. Forgive me.
We have to do that because if you've won on those, this point doesn't matter.
I just didn't want right at the end of submissions for a misunderstanding to arise.
No,
Obviously, my main submission is the test is met.
I understand that, but if that were right, we wouldn't be on this point. But you're taking the time of the court arguing this point, so therefore there must be something in it additional.
Yes, and the
What I'm
additional-
trying to ferret out, not very successfully so far, is what it is that is additional about this point. It can only be additional if you're wrong on the other arguments you've been making this morning. So if you are wrong on that, how does this point get you home? How does this point become relevant to Francovich, if you say it does?
The additional thing is that the court takes time and space to say that the principle of effectiveness will also be relevant, not only when Francovich has been satisfied, but one presumes, especially when it hasn't. And the principle of effectiveness means that there must either be the award of the contract to the right tenderer, to the meat tenderer, or the alternative remedy, which is the award of damages, in order to ensure that the principle of effectiveness has been complied with in a case of this nature. So
Now,
that's
Mr. Bozo, just so that I'm clear, of course I understand you did not appear below, but I don't think this argument was ever made to the judge.
it was not. It was made in different terms, which was that it's incoherent to have lifted the stay and then not award damages.
Well, there's a very easy answer to that. 2 different tests, 2 different times, 2 different sets of evidence.
We know that
So
effectiveness.
that's the answer to the incoherence, the factual incoherence or the procedural incoherence. But this is a point of law, as I understand it, where you say the principle of effectiveness is relevant even if otherwise the Francovich conditions aren't met. And that point wasn't argued before the judge.
No, it wasn't. That's not in dispute. But permission to appeal was given in well aware that the point wasn't argued before the judge.
Okay.
And so here we are. And I say that we step back for a moment and look at what's happened in this case. You have a suspension lifting hearing at which the judge said, well, I say that damages are going to be adequate, and indeed accept the submission that is to the effect that if the contract would have been awarded to Braceurself, then they should recover damages. The liability judgment proceeds, there is a breach, it does make a relevant difference. Then we get to damages, not sufficiently serious, no damages. So looking at the totality, what is wrong with this picture, my lord, it is that my client is left without any remedy by the system, as it were, either the front end or the back end, despite the fact that it has won on the critical middle. And I say, stepping back, the principle of effectiveness cannot be satisfied by a situation where this is not a loss of a chance case, damages were adequate and available, and however, no remedy is granted at all, not even the remedy contended for by my Lord Justice Dingemans of bid
Not
costs.
contended for. I was just checking that my understanding of French law was right, and that must of itself assume that therefore it's that is an effective remedy.
Well, I make no submission whatsoever on French law, my lord, and whether it's in compliance or otherwise with the directive. But my lords, that's the situation. And we have a situation now where at the undertaking or lifting stage, a brace yourself undertaking has to be made by the party that says it's not going to take a point on sufficiently serious. And that is unsatisfactory if that is how our system is being left to operate. As I say, we've got an example of that in box at Authorities Bundle 35 at paragraph 43. So I conclude where I began. In all the circumstances of this case, when my client should have the contract, in order for there to be an effective remedy, and the remedies directive says a decision not to grant interim measures shall not prejudice any other claim of the person seeking such measures, and there is no remedy, then whatever else, the principle of effectiveness kicks in to grant an award of damages. So, Lord, I should add that the remedies directive for some reason isn't in the bundles at all. But the index suggests it is, but it isn't. I'm happy to hand it up.
But it's not an issue between you, is it? I mean,
No.
the remedies directive provides that that there is an effective remedy for a breach of procurement rules and regulations. And as you say, there are principally two remedies: the award of the contract or damages.
And the decision not to grant interim measures shall not prejudice any other claim of the person seeking such measures. And that's Article 2.5.
Yeah.
I think it's in my learned friend skeleton argument, so you may not need more than that.
Oh, just give me the reference to that, because then I think I positively decline your kind offer. The remedies directive, what was the cross reference?
Article 2, sub paragraph 5, second indent.
And that's set out in the Miss Morris's skeleton, did you say?
I believe it is, yes.
Okay, well, she can give us the reference. Yes.
So, Lords, unless there's something else, and I'm sorry I've taken the whole morning.
No, thank you very much. Miss Morris, despite my best efforts, you can't start until 2 o'clock. And you will obviously need to leave Mr. Moser a bit of time to respond on the factual kit, plus anything else you say that is replyable to, but hopefully that's not so much, because we've trampled quite a lot of ground, I think.
My lord, I've been thinking about that. May I just try this with you? If I were to start at 2, and when to try and finish perhaps at 3:45, maybe I can go more quickly, then would that allow my learned friend half an hour to deal with, our respondents?
That would allow him...
Or would you like me to go more quickly than
No, 4:45 would allow Mr. Moser, and I can say this without even hearing from him, more than ample time to deal with any points that he wants to raise on any matters that you may raise. That would be extremely efficient.
Well, shall I make that my goal? And I will do my utmost to stick to it.
Fine.
If everybody agrees with that as a plan.
Yes, we do, and I can say that without question. Thank you very much. 2 o'clock.